was, they're asking the advocate the whereabouts of the client.
They're asking the advocate the whereabouts of the client. Is the client in the country?
During the time of the fraud, he was in the country.
Yeah.
But now he's telling the DCI that he was not in the country.
Or he was not in the country during the time of the fraud. But
yeah, that's what he DCI. But the advocate knows that he was in Kenya at the time of the fraud.
Yeah, so it touches on confidentiality. And at what point, you'd have to share that information. Is it confidential information? Should you not tell the court about it? Should you tell the court about it and all that stuff? So I think if you look at some of the duties that you have under confidentiality and some of the exception to that rule, of course, as the Advocates Act would say, if you know about an information that concerns a crime that, of course, is being planned or a crime that is going on, then you have a duty to tell that to the court. And of course, if they come to you, if authorities come to you and, they have a warrant that would mean that you have to give this information to the court, then I believe that at that extent or at that point, then you'd have to reveal that particular information. In this instance, I don't think any of those three circumstances exist. It's the same way people go to court sometimes and, maybe my client has told me that, you know what, Daniel, I killed him, but I still have rights. So is it a must for me to go and tell the court that I know he's saying no, I know he pleaded not guilty, but I know he killed this particular person. So of course I know that. So if whatever I know doesn't fall within the exceptions of confidentiality, then I want to believe that it is your duty to ensure that whatever you know is kept confidential, unless and until you yourself is asked personally to answer to this question. Then of course your duty to the court would mean that you'd have to tell the truth. And of course, in that instance, it will be that the authorities want you to answer that particular question. And probably they have orders that allow them, to put you on the stand and, ask you that particular question, and you have to be right. So I want to believe that before, and if you're not called, to stand and give your evidence, I don't think it is your duty to tell the court that, and again, this doesn't mean that I'm a bad lawyer or anything. I'm just looking at the exceptions of confidentiality and if this applies to the same. Mary, what do you think?
Yeah, actually, the reason I was asking was because I was confused about the exceptions, because the one that you described is you can only provide information if there is a future crime that is being planned on being committed. But in this case, the embezzlement was already done. So I don't know where we fall in that scenario, because the embezzlement was already done. So what the officers want to know, they just want to know where this client was at the time the embezzlement was happening. So it's in the past tense. So that's the confusion I had, hence I was seeking clarity.
I hope now you have clarity. I think the fact that it is in the past tense and you're not the one who has been put to the stand to say yes or no, I don't think it is your duty to just, wake up and say, oh, you know what, Your Honor, this person is actually lying and, he was not in the country.
Okay, thank you for that.
Yeah, Salim, maybe you have a different opinion. Go ahead.
No, not really different. I just wanted to agree with you and say that even the accused person himself is under no obligation to divulge that information because he's protected by the Constitution not to provide self-incriminating information. So that's the duty of the investigator, to find out information and to prove their case. They cannot ask the accused to help them prove their case. So other than the client advocate confidentiality, it actually, the question extends even beyond that, that even because the advocate is acting as an agent of the accused person, even the accused person himself cannot be forced to provide such information because that one would lead him to self-incriminate, which is against the Constitution. So I agree with you that the advocate is not under any obligation, not even the accused person himself can be under obligation to prove such a matter. Thank you.
Okay, thank you, Salim. And I think thank you for expressing yourself and for exercising your right to expression under the Constitution. And I think you have the right to keep silent. whether you have the right to, you have the right to keep silent, whether you have the right to, to say something that is wrong again. I think, Salim, that's a question for another debate or a question for another day. But yes, I want to agree with you that yes, the burden or the onus of proof is on the other side, and it is their duty to ensure that, they prove it. And in relation to your question, Mary, if you're talking about the advocate, no, it is not the advocate's duty to tell the court that, you know what, this guy is lying, this is the truth. Thank you so much, Salim, for that very, very good contribution. Mary, you want to say something?
No, I'm just saying thank you. That's well understood.
Okay. There was another hand. Anyone else? We can clarify this as quickly as possible, then move on to the next thing. Is there another question? Real quick, before we begin. Angela, please confirm if you are using a laptop. Please just inbox you. Yes, anyone else? Yes, Peter.
Okay, thank you. So I wanted to contribute to that discussion. I believe, for example, the practice of criminal lawyers is to defend accused persons and to persuade the court on their innocence, or rather to persuade the court that the matter has not been proved beyond reasonable doubt. So in this specific instance, I believe there's a very thin line between illegality committed prior to seeking advice and illegality committed after seeking advice. And that's why you have even people who have offenses, or who have been charged with offenses such as obtaining money through false pretense. They have advocates who represent them in court. You have stated a heinous crime such as murder. Those people are they have advocates representing them in court. So I think the confidentiality line only goes to the extent of information that they give the advocate, so as to give or afford the advocate an opportunity to build on their case theory and to be able to pursue, or rather represent them in court. However, the same confidentiality is waived in at the moment where, for example, let's say with the recent occurrences that have been that have started springing up of let's say advocates' accounts being used by fraudsters to connive people on the gold business. So in such an instance, I believe if someone gets to an advocate and they want now to use the advocate's privilege to engage in such malpractice, or they want the advocate's advice to further or pursue a certain illegality or a criminal offense, then that's where the advocate is obligated, pursuant to the law, to report the same to the necessary authorities. So I think the question can be answered, was it after seeking the services of the advocate or before seeking the answers of the advocate? So I think it is at that point that then the advocate will know whether, even if he's called upon by the necessary authorities to snitch on that client or to give information that that is privileged on that client, which path he will take. Yeah, and I think it's well provided for even in the Evidence Act that that states when an illegality should be reported by an advocate. Thank you.
Thank you. Yeah. So I think one thing that we have to say is it depends on when it actually happened. And of course, if it is a continuing offense, you know about it, it continues to happen the way we talked about the gold scams that we are having, you know that it's continuing to happen. And even if you told me that before we had this case, so long as it continues to happen, then yeah, you have to, you really have to tell the court about it. Like, then again, if you know about it later on and this thing is still happening, then yeah. So I think time really matters. But maybe I think in relation to your question, this is something that the advocate knew about it earlier on. They have not been called into the stand. The person giving evidence is the client. The client has lied and not the advocate. So I think to that extent, I think, Peter, you'd also agree that, the case is a bit different. But yes, thank you also for, for saying that, we really have to look into the timing, and that really matters. Peter, are we on together or?
Yes, we are.
Thank you, Peter. Yeah. So thanks for also bringing up that, that aspect. And of course, where it is a continuing crime here, you have to. You can't just say that. Thank you. So we are going to start our oral sessions. And of course, as you guys know, we always have different people volunteering themselves to be, as students. Of course, we are all students in, the legal profession, because there's so much to learn. But yes, what we're trying to do is to try and make you go through what you'd go through an oral session. And what we believe is this will help you to build your, I wouldn't say character, but to build your confidence. This will help you to probably make the mistakes that you could have made during that time right now, so that we can correct those mistakes, and just to help you to be better, just to help you to sharpen your skills, just to help you to probably learn how to, hold up the pressure and to do better, just to help you to also hear from someone else how, they are not doing the right thing, or how they are doing the right thing, how they're managing, how they're not managing, and how you could do better. Again, we say that the secret to this is, as much as you try, the more you try, the better for you. Practice, I wouldn't say makes perfect, but I believe that practice will help you to improve and to become better. I mean, it's like going before the court. Many advocates will tell you that at the beginning of the career, the first day is always crazy. I mean, you don't even know what's going to happen. You don't know the questions that you expect. Of course, you'll be told this is what happens, that is what happens. But the more you continue doing it, probably the first one could be bad. The second one probably will get easier. The third one, the fourth one. In your fifth year, you'll be going to court, and there's some things that will not stress you. I mean, confidence will be the least of your worries. What you'll be thinking about is, winning, or probably just doing that case to the best of your abilities and taking the next one. So it's one step after another. Here we are ready to take those baby steps with you. We are ready to, make those mistakes. We are here to correct you when you make those mistakes, and probably and hopefully you are going to be better when your oral session comes. So let us all just try our best to listen in. If you're not the one volunteering, try your best to see what you can improve on. But most importantly, let us also try to volunteer ourselves, so that, we are also able to develop personally, and so that we can also see and feel how we'd feel in that particular situation, because this gives you that platform. This gives you that platform. The good thing with this platform is you can make that mistake and I can't take you anywhere. But at least for that mistake, you can learn. Okay, so that is it. Let us have our first volunteer. Me and Angelo are going to ask you a few questions. Please, let us have anyone who is ready, anyone who is willing. Anyone who is ready and willing. Anyone who is ready and willing, guys, to take a few questions for us today. Any volunteer? I don't want to choose anyone because I don't think that's proper. But anyone who is willing to take the stand.
I think there's a hand of Gisheru Mary.
Oh, so thanks, Peter. Gisheru Mary.
Yes.
Sorry, I didn't see your hand. How are you?
I'm very fine, thank you.
Okay, thank you for being our first volunteer today. You've broken the record. So I think we're going to start with Angelo. Angelo, are you ready?
Oh, God.
Yes, born ready.
Born ready. Mary, it's okay. Don't say. Yeah, you can make all those mistakes. It's fine. I also have for you, but don't worry. Angelo, take it away.
All right. Thank you. Mary, good morning.
Good morning to you too.
Kindly introduce yourself.
My name is Mary Gisheru, a member of Class B, Farm 6, student registration number 2023-0873.
Okay. Thank you, Mary, for coming today. to attend to your orals. I'm going to ask you a few questions, and my colleague Daniel will also ask you a few questions. Thereafter, we'll give you our comment. Kindly please tell me, how do you place an accused person at the scene of crime?
Thank you for that question. We have not yet reached there with our lecturer, but I'm going to try. I think I would place the accused at the scene of crime by looking at the evidence presented to me by the prosecution. I would take in interest to the document in subfile B, the documentary evidence. I will look at the documents presented there, the photographs, the sketches, and also I would have a look at subfile C, and not really subfile C, but mostly subfile B, where I will see the documents. And yeah, that is how I would place the accused at the scene of crime.
Okay, thank you. Can you please tell me the rule in Rylands versus Fletcher?
The rule in Rylands versus Fletcher is about negligence, and it states that you should take care of your neighbor. It sets out the neighbor principle, and it says that you should take care of your neighbor by paying caution to actions that are reasonably foreseeable that can cause harm to your neighbor. Yeah.
Very well, very well. Can you please tell me what is your understanding of Section 3.5 of the Law of Succession Act?
Section 3.5 of the Law of Succession Act came into place to cure the harm that was seen in the cases of Riogola and Riruenji, where initially a woman who was married, who was subsequently married by a man who had previously had a monogamous marriage, was not seen as a wife and was not allowed to inherit, but subject to Section 3.5 of the Succession Act, it provides that notwithstanding any law, a woman who subsequently gets married through a polygamous form of marriage, like this second marriage has to be polygamous, will be allowed to inherit, will be considered a wife, for purposes of succession. Thank you.
All right. Thank you. Finally, please give me the hierarchy of courts in Kenya.
Thank you for that question. The hierarchy of courts in Kenya, we have the superior courts and we have the subordinate courts. The superior courts, we have the Supreme Court that is provided under Article 163 of the Constitution. We also have the Court of Appeal, which is provided under Article 1E4 of the Constitution. We also have the High Court, which is provided under Article 165 of the Constitution. And we also have magistrate courts, which comprise of the Chief Magistrate Court as the highest ranking magistrate court. Then we have the Senior Principal Magistrate, then we have the Principal Magistrate, then we have the Senior Resident Magistrate, then the resident magistrate, and the lowest court, we have the small claims court. Thank you.
All right, so that's all on my part for now. Thank you. Daniel?
Thank you, Angelo. Hi, Mary.
Hi, Daniel.
How are you?
I'm very fine, thank you.
Okay. Do you support any football team?
Mm-hmm.
Or you like basketball, like cricket?
I think I support Chelsea.
Yeah?
Chelsea, yes. I do support.
Oh, you support. Oh,
Yeah.
okay. That's nice. What's your take on the war between Ukraine and Russia?
I would apologize.
No,
What do you mean by my take?
what do you think about it? Is it proper? Are there offenses that are being committed? I mean, the other day I heard that there was an arrest warrant issued against Putin. What's your opinion? Who is wrong? Who is right?
I have not been following quite keenly, but I don't think it's right based on what I've been seeing on social media. Is some people are getting killed in the middle, and according to me, that is not right. Yeah.
All right. And in accordance to what you learned probably in international law and other factions of law that are closely related to international law, do you think it's proper for another country, for example, let's say Kenya, to invade Tanzania? Is it proper?
No, it is not.
What if it is for self-defense?
Our Kenya invading Tanzania because of self-defense.
Yep.
I still don't think it is proper.
Okay. Sawa. That's fine. Any types of interlocutory applications that you know about?
Yes.
Kindly just state.
We are yet to reach there, but I will try. We have a notice of motion. We have chamber summons. We also have yeah, those are the ones that are coming to mind.
Okay, it's fine. So where have you guys reached so far in civil litigation?
Our last class, we were learning about summons and service.
So you've done pleadings?
Yes, we have done pleadings.
Oh, okay, that's fine. Who is your civil litigation lecturer?
Gadgadu. Mr. Gadgadu.
Yeah?
Mr. Gadgadu.
Okay, that's fine. So let's say today I come to you and tell you that, I'm working at this particular organization and they haven't been paying me as per our contract. I work long hours and, I'm complaining about this because I'm not able to see my family. My life is not moving towards the right direction, probably because, I don't work within, the limited time that I'm supposed to work within as per the contract. And, I feel like things are just not going through. Are just not going through, right? And I just want to go to this court. I want to go somewhere. I need the courts to help me. So I come to your chambers and ask you to advise me or help me deal with this particular problem. Which pleading would you file and in which court?
Since it is a matter about employment, you have stated that the actions that are being done to you are breaching the contract that you entered. between you and your employer, you will go to the Employment and Labor Relations Court. It is a court that ranks similar to the High Court, and the pleading that you're going to make is statement of claim. And in this statement of claim, you will also file it with supporting affidavit.
Where are you filing it? Sorry.
I said at the Employment and Labor Relations Court.
Why not the High Court?
Because the Employment and Labor Relations Court has been given the same rank as the High Court, but it specifically deals with matters to do with employment.
So what would happen if I took the case to the High Court? Since they have the same status anyway.
If you took the matter to High Court, you will be breaching the doctrine of, I cannot quite clearly remember it, the doctrine of exhaustion, since it provides that you are supposed to exhaust all other avenues before you approach not really the doctrine of exhaustion, but you cannot go to High Court because the Employment and Labor Relations Court has been provided under the Constitution that it is the one that is mandated to hear matters that are touching on employment matters.
Okay. What's jurisdiction?
Sorry?
What is your understanding of the term jurisdiction?
Jurisdiction is where you're supposed to file your matter, and I can relate that to the case of owners of motor vessel Lillian S versus Caltex Oil Limited, where Justice Nyarangi was stating that jurisdiction is everything, and without it, the court is not mandated to take any other step. So before deciding, before embarking on filing your case, you're supposed to know where that course of action or where that case, the court that is supposed to listen to that matter. Because if you file in another court, or rather if you file in a court that does not have jurisdiction, either from the Constitution or from the law, pursuant to the case of Samuel Macharia versus KCB, jurisdiction is given by the Constitution or via a statute. So if you file a case in a court that does not have jurisdiction to hear that matter, the court cannot even take any step to listening to your matter. Thank you.
All right, just very, very last question. What do you understand by this Latin term, nolle prosequi? Nolle prosequi.
Nolle prosequi. I'm sorry, I cannot remember, but it has to do with prosecution. Apologies.
Private prosecution? Could it mean private prosecution? Maybe. I'm also not sure.
I cannot say yes or no. Thank you.
Okay, fine. Okay, maybe you can Google just after this because it's a Latin term and you'll be able to know. But yeah, thank you so much for taking the questions.
Thank you for your time.
Okay. Angelo, your reaction?
Okay. Thank you. Thank you so much, Daniel. Thank you. Is your name Mary? What is
Yes.
your name is Mary?
Gishiru.
Okay, okay. Ms. Gisheru, thank you so much. You really did so well in your first attempt. I was really amazed by the mesmerized, sorry, by the authority you cited, because as we are talking right now, it is the locus classicus case on the aspect of jurisdiction. That is the Samuel Macharia case versus Kenya Commercial Bank application number 3 of 2011, if I'm not wrong. So even how you bring about the aspect of doctrine of exhaustion, Daniel tried. Yes, you really did well, but I know he will come in later. And also on the aspect of Nole Prosecute, this is something should also be on your fingertips. Maybe you are not there yet, but I know you'll comment on it. So mine were easy. You did really well on my part. So the aspect of placing the accused person at the scene of the crime, the person who usually teaches well is Dr. Omosa, who is no longer there now. But I will mention just 3, but I believe there are several. Okay, so you can place an accused person at the scene of crime. For example, when you use a fingerprint. Okay, you can do the same through eyewitnesses. Due to the aspect of technology nowadays, you can do the same using what is known as CCTV cameras. You can place an accused person at the scene of the of crime using something called dog identification. Someone can, was this the person? When, let's say, when we are in court, because I believe in another set of oral exam, we will ask you to differentiate between dog identification and identification parade. We can also tell you to differentiate between what is known as identification by recognition. So another way you can place an accused person at scene of crime, it is what is known as ID parade. Okay, so that is it on that aspect. And then on the aspect of Rylance versus Fletcher, the rule there, it is on the aspect of strict liability. I believe you can read more on it. They might not ask about 50 students, but there will be one person who will be asked that question. Same like last time when we were talking about Solomon versus Solomon and another Force versus Avato. So there are these locus classicus case that you used to know in when you are doing your LLB, you will still be asked on that. And then on section 3.5, I don't know if it was you, Daniel, who explained it to us really well last time during our this set of trainings, but there are 2 separate concepts, which again will depend on which class that you are in. Are you in the class of Mrs. Rusto, or are you in the class of Miss Anastasia? Okay, I was in the class of Miss Anastasia, which I believe it has been adopted as the correct position when you are explaining section 3.5. Okay, on the aspect of defining this wife, who is a wife for purposes of succession. Okay, for example, in this regard, if you look at it, it has started, I don't have my act here, but something like notwithstanding. Okay, it doesn't matter whether you are in a monogamous marriage. Okay, so in that aspect, a wife that is married under customary law is protected under this particular section. I might not give you a clear explanation, but there is a wife that has been introduced, which is not there in the Marriage Act, okay, which is not recognized under Section 6 or Section 9 of the Marriage Act, but it is recognized under this particular act. Like the way you said, Rio Gola, okay, Riruenje, okay. Then now we come to the decision that was made in 1994. In 1984, that is after the enactment of this particular act. I have forgotten the case, but it now introduces this particular aspect, which led to incorporation of this particular section to provide that particular protection. So if you are married under, let's say, as a second wife, and maybe the first wife was married in a monogamous, let's say, in church or in accordance with the Marriage Act, so you will still be protected for purposes of succession under the Law of Succession Act. But let's say if the roles were reversed, for example, the person was in a polygamous marriage or a potential polygamous marriage, and then he purported to marry under the act, for example, marrying a second wife under the Marriage Act, then now courts have always said that that particular person has or had no capacity to enter into a monogamous marriage, because what he has contracted is a polygamous or a potentially polygamous marriage. So that is a simple explanation I can give in that respect. I believe maybe Daniel will expound on it. And then on this other school of thought is that one of Mrs. Ruto, whereby she's saying that there is nothing like a wife under Section 3.5. Okay, Section 6 and Section 9 are very clear. All marriages are registered. Okay, on the aspect of definition of marriage and those type of marriages. So there is nothing like a wife under Section 3.5. So she said that according to her, that Marriage Act was the latest act that was enacted. Therefore, it has repealed, okay, Section 3.5. That is according to her, or that is what I have heard about when we were attending sessions like this. So, and then finally on the hierarchy, you did well there, but I needed you to just go head on. Don't tell me about superior courts or the lower courts. The hierarchy is very clear, whereby the highest court in Kenya is the Supreme Court, Court of Appeal, High Court, Magistrate Court, and then very recently we have now the Small Claims Court. So you did really well on my part. Daniel, take it away.
Thank you. I asked you some questions. Not let prosecute, just let me start from there. It means refuse to pursue. Yes, the reason why I said that maybe it is related to private prosecution was just really due to that particular answer. But I think you tried because I think you said that it's something to do with prosecution. So yeah, at least that would count as something. And I think your last answer was also good when we're talking about jurisdiction. You talked about owners of motor vessel, Leland S versus Caltex Oil. I don't know if it's the other way, that is the way it is. But yes, that was also a good answer to that particular question. And, I feel like you could have just used the same answer, what you've talked about in that case, to answer the question that I asked you, like, what is jurisdiction? So I feel like you could have just quoted what was held in that case. Because I said, in the case of owners of motor vessel, Leland S versus Caltex Oil, it was said that jurisdiction is this, and this. And the reason why I was asking you that is because, during our time, someone was asked to, define what jurisdiction is, and they said jurisdiction is everything, and they left it there. What is jurisdiction? Jurisdiction is everything. So, sometimes it's very important that we don't just talk about jurisdiction. It's important that we know what jurisdiction is. Then I asked you about different types of interlocutory applications. And yeah, so these ones include striking out, third party, summary judgment, applications for Mareva injunction, Anton Pillar orders, temporary injunctions, interpleader, security for cost, examination of a person, interrogatories, and discovery. So maybe you haven't done it yet, but just try your best to, to also know about these things, especially now that orals are coming up. If you get that chance, try to go ahead a little on things like applications. These are questions that in most instances, probably someone will ask you to just tell them different types of applications. If you can, please just try and answer. Then I think there's a question that I asked about a football team and all that. That was just to make you relax, so that you're not tensed. So yeah, when you get such questions, just calm down. Probably the person has realized that you're tensed up, and they're just trying to calm you down. So just chill and be okay, and just answer it. If there's no team, just say, well, I have no team, but I like basketball, and my best team in basketball is this one and this one. So there's no particular answer that I'm looking for. I just want you to calm down. Again, when I asked about your opinion in the Ukraine and Russian war, Again, I didn't want a particular answer. You didn't have to tell me that this is the answer. I mean, there's no answer. Everybody has their own take on that particular war. China would tell you, fine, I mean, fight for what you want. You are fighting for democracy. These guys came too close. Russia would tell you that, we are protecting ourselves. We don't want monopoly. US has been doing everything and all that stuff. But again, someone will tell you it is wrong, no matter what you're doing, to invade another country. So I just wanted your opinion. You can say anything, whatever you feel. There's no particular answer to that question. This is what I was asking you, is just to know whether you are a debater, know whether you'll just open up and say something and not get closed up. But it's fine. I think you tried saying something which is actually good. But the tip I'd like to give is, when you get such questions, just speak out your mind. There's no particular answer to that question. Especially if I begin with, what is your opinion on this particular thing? And it's politics and all. Just open your mind and say what you think. I just want to know if you are a debater. I just want to know what would you say? What do you think about it? I just want to know your opinion. So there's no particular answer to such questions, none at all. Then when I asked about international law and the fact that you have the right to invade another country, and the reason that's why I talked about self-defense is because it's an exception to that particular rule. If it's for the purposes of self-defense, and you guys have talked about it, you've told the Security Council about it. I mean, you have the go-ahead, and you're able to do such, and I think that could be a defense in that particular circumstance. Which other question did I ask you that maybe you want me to address, Mary? Any other question that I asked that you'd like me to address?
You answered all of them. Thank you.
Okay. Now, one thing I'd like to tell you that, Mary, this is why we are here, to make these mistakes. You have done well. Yes, some mistakes are there, but you have done well. But this is the opportunity to do what? To do better. And at least for you now, you know how it feels, Mary. So when you're preparing, you know what you are preparing for. I'm not saying that it's hell, but you need to know some bits here and there. You need to at least try and, just speak. Now, Mary, if you get these open-ended questions, what is your opinion? That is the time to just calm down and share what you think. If you can use a lot of time doing that until they tell you, okay, fine, that's proper. If you want to engage them more, do that. Just do that. Probably in most instances, they're just asking you that to calm you down, to give you a question that really doesn't need you to think. If they ask about your football team, it's not weird. Fine, just say something about it. It's okay. Say anything. So just be easy, and I think that moment will also help you to calm down and to think as you move forward. But you did well. You tried. This is the first time, Mary. It doesn't matter how it was. I'm not saying it was bad. It was good. You tried. You did your best, Mary. You can only do better. So thank you so much for volunteering yourself. Thank you so much for this particular first session, and you're a champion, Mary. Okay.
Yes.
All right. Thank you. Who else would like us to, who else is ready? Someone who would like to take questions. Mary has done it. She has now gone through it. She's now a proud lady. She knows how it feels. She's preparing to be better. Anyone else who would like to also try and also to help others learn in the process? Anyone really? If the questions that Mary went through are very hard, I think we're also going to try to just try and not ask really, really hard questions. Angelo, I hope I hope we're taking notes. Yeah. Anyone? Yes. Peter. Well, okay. Let's go with you, Peter. You did so well last time. Let's go with you. I thought we'd have someone else, but yeah, let's go with you, Peter. You ready?
Yes, I am. Thank you.
Yeah, okay. So use a guest. Nyambura, if you're ready, please just let me know. I know you've joined.
I am.
Oh, yeah, okay. Then I think you can start. Then after you, we can have Angelo. Angelo, I hope you don't mind. Nyambura, take it away.
All right. Hi, Peter.
Hi to Ms. Nyambura.
How are you today?
I'm good, thank you.
So I'm just going to ask you a few questions. And we'll start with a very simple question. Let's say someone has robbed you. Can you prosecute that person privately, or can you take them to court yourself?
Yes, thank you for that question. So if someone has robbed me, and for example, I've tried to pursue the same with the relevant bodies, that is, for example, the police, I've reported the same to the police, and the police have failed to take the requisite steps to ensure that they bring this person to book. And then after the police have failed, I proceed to the ODPP's office, who are in charge with the prosecutorial powers. And I also pursue the same with their office, and they also look like they're adamant to pursue my matter. Then I can proceed to lodge an application with the court for pursuing private prosecutions, and it will be at the discretion of the court to either, upon the evidence which I'll present, agree with me or disagree with me. And in the instance that they agree with me, then I'll be afforded the floor to present my case against the person who had robbed me. Thank you.
Okay, that's a good response. Now, we both know that the Supreme Court has a mandate to give advisory opinions to government bodies, if need be. So my question is, are these advisory opinions binding on other courts, on the parties who sought for the advisory opinion, or what's the position for advisory opinions given by the Supreme Court?
Okay, thank you. So I'd probably give a trail of from the past causes which were brought before the Supreme Court, considering that they had then the jurisdiction to institute the suit, for example, the IEEC. So initially the court was of the position that such matters would only bind the specific organs of, for example, the government that have sought that advisory, and not bind other organs of the government. However, following the subsequent applications that have been made before the Supreme Court, it has been decided that the decisions remain binding to all organs of the government as they intrinsically touch on their mandate. For example, let's say the recent matter that was presented, though it has not yet been decided, for example, the NSSF issue, in the instance that it is taken to the Supreme Court, the Supreme Court, the decision that it is going to make will be a decision that will cut across all public servants, or not even all public servants, all employed persons. So to that extent, I believe that the decisions which are given by the Supreme Court on advisory basis should be binding on all government organs, and more specifically the organ or the parastatal that has sought that advisory opinion to stand guided. Thank you.
So just a follow up on that one, Peter. So assuming the Supreme Court has given an advisory opinion to NSSF determining something, and then a similar matter comes up against a different government body, but now it has come up at the High Court. So is the High Court bound to go with what the Supreme Court said?
Yes, I believe the High Court is bound with the decision which was made by the Supreme Court on that specific issue if it arises again in the courts.
Okay, moving on. I believe you've done Campanile, have you?
Yes, we have. Yes, I have, sorry.
Okay, so what's the difference between an ordinary resolution and a special resolution?
Okay, thank you. So a special resolution is one which is made after a meeting which has been called for by either, for example, the shareholders or the creditors outside the normal processes. For example, we know that the AGMs is where now we have these meetings. Oh, sorry, the AGMs is where we mostly have the ordinary resolutions. And so a special resolution requires a special majority for it to be passed, but an ordinary resolution requires a simple majority for it to be passed. Yes, thank you.
Okay, just a follow-up. What do we mean by special majority? Like, if you're talking numbers, what are the numbers for special majority?
Okay, I believe the numbers for, let's say, for example, a simple majority will be at least 2/3 of, let's say it's a decision on the shareholders. I think 2/3 of the shareholders should at least make or agree with that resolution. And special resolution, I believe it's anything above 2/3. Yeah, but I stand guided.
Okay, just another question on commercial. Who can call for a meeting in a company?
Okay, thank you. So the people who can call for a meeting in a company are 1, the shareholders, 2, the creditors, and 3, the directors of the company.
So can the shareholders call for a meeting without the director's knowledge? Or what's the procedure if the shareholders want to call for a meeting?
Okay, thank you. So the shareholders can only call for a meeting in the instance that, for example, they have served a notice to the directors of a burning issue or a very urgent matter which needs to be addressed, and the directors have proceeded to either not adhere to the issuance of that notice, or have, let's say, given a blind eye to that notice which has been given by the shareholders. So there's a timeline. I think it's 28 days, though I start guided. And in the instance that, again, the directors fail to order that meeting to be done, the shareholders should have, I think, a simple majority of 50%. And then if they are able to append their signatures for a meeting to be held, then they can then proceed and do that meeting, or even proceed to the courts and order and ask the courts to give them the leeway to proceed and have a meeting.
Okay, so the last question is on probate and administration. Now, we both know that, how do I phrase this? A cohabitee is a beneficiary if they can prove that they were cohabiting before the deceased person died. What is the case law that supports that position?
Okay, so the case law that supports that decision is the decision by Mustafa in the case of Hortensia Wanjiko. Yes, the case of Hortensia Wanjiko is the one which set the ground rolling with the presumption of marriage that is brought about by cohabitation. And it set the requirements for cohabitation, which are there is consistent and also, for example, there's consistency in the relationship. The people have said they have stayed together for a long time, and also the information that will be got from the people who are surrounding them will be information which would be to the positive that these people have been indeed together for a long time. Yes, so that's, and also there's a recent decision that was issued by the Supreme Court. I think it is MNG versus B something. So I stand guided on that. But there's also a recent decision that also affirmed the position of cohabitation, but only to the extent that the same is to be used for the division of the property. Yeah, since it's not recognized as a marriage under the Marriage Act.
Okay, so I'll let my colleague take over, then I'll come back and give my feedback.
Okay, thank you.
Okay, Peter, I have 2 questions for you so that we can also have your colleagues. My first question is, can you please, you have been invited, which university did you attend?
Kenyatta University School of Law.
Very well, very well. Parklands, It is not Githurai University. Okay, so.
Parklands.
Okay. So you have been invited back to your campus, give a talk to the LLB students first year. Of course, we know they will have challenges. Maybe you will get only 20 students. So you have been invited to give a talk advising LLB students on what they can become after being admitted as advocates of High Court. Can you please tell me the kind of talk that you will give them on what they would become?
Okay, thank you. So the kind of talk that I would give them is first, after the admission as advocates of the High Court, for them to practice, they need to have a practicing certificate, which will be issued to them once they
I'm
apply.
sorry, Peter.
Yes.
I was asking for you to give a talk on what they would become after being admitted to the High Court.
Okay, thank you. So what they will become is within the law area, there are different areas in which they will work under. For example, they will decide to pursue the line of being litigation advocates, which mostly deals with matters under dispute resolution, that covers litigation, they can also pursue the line of the alternative dispute resolution mechanisms such as arbitration. They can become arbitrators, they can become mediators under the realm of law. They can also pursue another line of becoming corporate lawyers. And so becoming corporate lawyers, they will be able to work under different departments. For example, they can work under for example, telecommunications, media and intellectual property. They can work as, let's say, real estate lawyers. They can also work as conveyancers, conveyancing lawyers. They can also work, for example, in the project and finance departments of different firms. The other area in which they can also pursue, they can also work as they can also work as company secretaries, or even serve as CEOs or directors in big companies and even big government parastatals. They can also work under government offices and boards. For example, they can work in the AG's office, they can work in the different boards assigned to the government, and also serve as chairpersons.
Okay.
Yes,
all right, thank you. Okay, let's say my good friend Daniel, I actually borrowed some 700,000 Kenyan shillings from me, but he has actually refused to pay me back. I don't know for what reason. Now I have come to your chambers, and I would like you to advise me appropriately on where to institute the suit. Maybe can you please advise me now? My good friend has refused to pay me back my Kenyan shilling 700,000.
Okay, thank you. So there are two channels which I can advise the client to follow. One is, for example, through the normal way, which is doing a demand letter to the client. Sorry, not to the client, to the person who owes the money. And if they fail to agree with what we have written in the demand letter, we can then proceed to file a plaint in court. The other path we can use is filing a statement of claim under the small claims court, since it has jurisdiction to listen to the matter, considering that it's 700,000. and the Small Claims Court has a jurisdiction to listen to all matters that don't surpass 1 million Kenya shillings. Yes.
Can you please tell me who sits in the Small Claims Court?
An adjudicator.
Very well, thank you. Daniel?
I think it's Nyambura.
Yes. Now, let me just go through the questions real quick. On the matter of private prosecution, you did pretty good. I'm not going to add anything. That was nice. So what you're basically doing is outlining the procedure you need to follow if you want to privately prosecute someone. So you need to ensure that you've reported to the police, you've reported to the ODPP, and no action has been taken. So that way the court may allow you to prosecute the matter privately. If it doesn't, then you cannot prosecute that matter privately. But of course, you can appeal that decision of the court, as we all know that any decision of the court is appealable, unless it's that of the Supreme Court or that of the Court of Appeal. If the matter is not of public interest, and I've forgotten the other one, but yeah, those two. So that one you did really well. Now on the Supreme Court's advisory opinions, I want to actually refer you back to international law. When we were doing the international court in International Court of Justice, something like that. Not the ICC, the other one, ICJ. I can just abbreviate it. I've forgotten the full name. But if you look at the ICJ, it gives advisory opinions. But what an advisory opinion means is that the court is just interpreting that concept. Or let's say we've gone to court, we want an advisory opinion on a certain law. So what the court will be doing is interpreting that particular provision of the law. So it does not mean that decision or that advisory opinion is binding. However, if someone goes to court using that argument and get a decision in their favor, then that decision coming from that matter will be binding. But generally, advisory opinions are not binding. Just look at ICJ and basically just look at the role of advisory opinions. It's just the court interpreting a certain concept. Now, on ordinary and special resolution, you did pretty well on ordinary. Ordinary, it means majority of members present and voting. So let's say 50 people are present. If 27 people voted for, if all 50 voted, then 27 voted for. That is an ordinary resolution. Now going to special resolution, first of all, for it to be a special resolution, it has to have been proposed as a special resolution. So when you're calling people for a meeting, you're telling them you're going to have a special resolution. Now, when it comes to the decision, now let's talk numbers. For it to be termed as a special resolution, then it has to be more than 75%. Let me give an example. If it's 100 people present and voting, remember someone could be present and they don't have the rights to vote. So you need to be very careful. So if it's 100 people present and they all voted, then for it to be a special resolution, then 75 of them at least need to vote for that resolution. So it has to be 75%. But ordinary resolution, you did pretty well. Now, when you talk about who can call for a meeting, generally, the people who can call for a meeting are the directors. However, shareholders can call for a meeting, but they need to notify the director. They need to ask the directors to do it first. So if the directors don't call for that meeting, then the shareholders can call for that meeting. Now, for you as a shareholder to call for a meeting, you need to have at least 5% shareholding. It doesn't mean that if you have 1%, now you can't call for a meeting. You can team up with people up until you get at least people whose shareholding reaches 5%. So once you have that, then you can call for a meeting. So you need to have at least 5% shareholding. Again, I've said it doesn't have to be ati wewe peke yako ndo uko na that 5%. You can call your friends so that you have their support. And once you've gotten to 5% shareholding, then you can go ahead and call for a meeting. Now, the last decision was on cohabitation. You did pretty well. The case is the Yahweh case. However, if you look at, you quoted it, but you failed to note that there are additional requirements. So I'll just give you the citation of the case. That's the Mary Nyambura Kangara versus Paul case. It's Paul Ogari Mayaka. So if you look at that case, in the previous Yahweh case, there were, how would I put it? There were like 3 or 4 requirements. Now, if you look at the Yahweh case, it has added several requirements for how would I put it? For a situationship to be considered a cohabitation. So go through that case. It is going to be of help. It's backing up the Yahweh case, but it has given additional requirements for cohabitation. Otherwise, you did pretty well. If you keep at it, you'll do well during your orals. Keep it up.
Thank you.
Peter, on my end, I believe you did well. So the first question you did not answer it straightforward, because I believe as a career or what we become after our admission, we either become prosecutors, others will become judges, others will become magistrates, others will work as legal counsels, or do they call themselves state counsel at the office of the Attorney General. So others are advocates. Of course, you have been admitted as advocates. So whatever you are describing fall under that, like conveyancers, they are advocates. They work in litigation, they are advocates. So I wanted you to answer it in those terms. And on those two and those other 2 questions, you did well. Although I only wanted you to, I was testing you on the aspect of small claims court. So that's all on my part, Daniel. Thank you. You did really well.
Thank you. Peter, any questions?
No, only want to thank them for the guidance they have given me. I've also learned a lot from the feedback, and I keep growing every day. Thank you so much.
Awesome. One example that maybe people can take from me is keep trying, keep going. Another thing that I can say, Peter, yes, Njeri, you're next, is that, no matter the question, however hard it is, Peter, you had something to say. And I think that really stands out. I mean, sometimes you'll go to courts and you have a case that, you know very well, I mean, there's nothing to say, but you can't just sit there with your client and tell them, I have nothing to say. Sina maoni, I have no comment. No, you have to say something. And Peter, I like the fact that you're resilient. You'll always get something to say. Someone will say, go through the corners, but you have something to say. Keep it up, keep going, at least try, and I believe you'll do well. Peter, that was a good one.
Okay, thank you. Before we proceed, I have a question.
Yeah.
I have this difficulty between, or drawing the distinction between how why you'd lodge a matter before the small claims court and not the usual way of filing the pleadings of demand letter, plaint, that procedure. So what is the most unique or distinctive factor that you need to look at for you to know which court to lodge now we have that new court of the small claims?
All right. I'll say something. I think Angelo will also say something since he's the one who asked the question. I think, first of all, our courts or our judicial system would like to ensure that you give each and every person a chance to deal with these cases before they go to the courts. Of course, if you look at Article 159 of the question, it says that, I mean, the courts will do their best to ensure that ADR and other forms of ways of dealing with matters are given respect, and that they're given consideration. So of course, the reason as to why I think it is important to give a demand notice even before going to the small claims court is just to show the court that before I came here, I tried ADR, I tried this, I tried sorting out this issue, and it didn't work. It didn't work for me. So I think it's always safer just to go through, give a demand notice, try and see if they'll answer. If they don't give you anything, then of course go to the small claims court. Now you are asking, what is the distinction? Why would I decide to go to a small claims court and not to the high court, not to this magistrate court? So of course, Peter, first of all, it depends with the money that you're talking about. So if you're talking about 20 million and above, then of course you know that we are going to the high court direct. If you're talking about any amounts that are below that, then of course we also know the categories: 15 million and below, chief magistrate court. So basically, what you should look at mostly is the amount of money that you're talking about, and that amount of money will help you to know where you are supposed to go, where you should go, and where you should not go. Chief magistrate, 20 and below, you go to chief magistrate. 15, you go to senior principal magistrate. 10, 7. And that's why I think Angelo tried his best to insist that, Peter, what we're talking about here is 700,000. So registered magistrate will deal with 5 million. So if you have anything below 1 million, goes to the small claims court. Again, just looking at the principle of exhaustion that I think one of us talked about here, I know that maybe someone would say, I mean, the Constitution says that you can go to maybe, let's say, the High Court with any case whatsoever. The High Court will look into it, and it doesn't matter this and this and this. But again, it is important that we don't just bring every case. We don't just push each and every case to the High Court. So it is important that we first deal with it in these other institutions, in these other spaces that we have before we go there. You could go there and the High Court just tells you to go back. So demand notice, why is it important? So that you give a chance to ADR before you go to courts. Courts are already dealing with so much. It is important that you also try and look for other ways. It is only when that is not done, my opinion, and I think what I think would be very important to do, if that doesn't work, then if you're talking about 700, something below 1 million, go to small claims court. If it is 1 million above the case, of course, you know that we'd go to the magistrate courts, rising up. 5 million resident, 7 million senior resident, 10 million principal magistrate. So I think money would really direct you. And of course, location would also direct you, Peter. I don't know if that answers your question at least.
Yes, it does. Thank you.
Welcome. Angelo?
I have nothing else to add. I believe you have covered everything. But for Peter and the rest who are here to go read on it, especially the doctrine of exhaustion. And if you realize nowadays, every statute, it doesn't matter what it is. Let me just pick one up. For example, this particular act called the name. Is it called what? Land Use Planning Act. Which act is that, Daniel?
I don't know. I think Use Planning Act or Physical Land Use.
Yeah, Physical and Land Use Planning Act.
Yeah.
So you see, in that particular act, Section 40 of the Physical and Land Use Planning Act has provided for procedures if you want to institute a claim against a county or against the state. Okay, it has provided for internal, I cannot say internal mechanism, but we do say like statutory mechanism which have been established. Or let's say if we talk about the matters relating to work injury, like if you look at WIBA, it has provided that, for example, in case of work-related injuries, the first port of call will be the Office of the Director of Occupation and Safety Health Services Act Services. Sorry. Okay, so before you go to court, you file your claim first will go to the director. So like here, there's something called County Planning Authority. Okay, for example, if the county just come, they take away your land or something like that, anything relating to physical planning. Okay, so you go where? To the county planning authority, then you go to the license committee before you go to the ELC. Okay, so you see the courts are overburdened, and that is why you see small claims court are coming up. There's also need for something called the time conclusion of matters, oxygen principle. Okay, if you look at section 1A, 1B, and is it 3A or 3B, okay, of the Civil Procedure Act, like that aspect of efficient time conclusion of matters or something like that. So you just look into it. I believe the time is running so fast, so it is a big concept to be explained in few minutes. So that's what all I can say, Daniel.
Thank you so much. Thank you so much, Angelo. Peter, I hope you're okay.
Yes, I am. Thank you.
All right. That was good. I think we had someone who was ready to take the next question, Jerry or someone.
Hi. Mine is not that I had a question to, I think it was Nyambura, on the
Okay.
issue of advisory opinions. I needed a clarification. There is a 2011 decision, the IEC, the Interim Commission on Elections that was there. They had sought an advisory opinion, but then they did not do what the advisory opinion said. And then now a matter arose in 2011 where the court was supposed to say whether advisory opinions were binding. And in that case, in that IIEC at paragraph 94, the Supreme Court said that an opinion of the Supreme Court, that such an advisory opinion of the Supreme Court is binding as much as any other decision of the court, as hearing indicated. So what I understand from that decision of the court is that Kenya is different from what the rest of the world is doing. That in the rest of the world, the advisory opinions are just that, they're opinions. But basing on the case, on the ruling that was given by the Supreme Court, the judges were, if you go, it is a very lengthy ruling, but the court was of the opinion that why should we take our time to render our minds and go through the law to try and give something, and then it will not be binding. So from that case, this was also a discussion that we held with one of our mwalimus. At one point, Gad was taking us through criminal litigation, and he's the one who brought this case up. And his opinion was that in Kenya, the situation is different, and advisory opinion rendered, they bind both the party who sought it and any other person, even though you're not the person who sought it, any other person. If they have decided on an issue in an advisory opinion, it is binding and it is followed by even the other courts below, as if it was a decision of the Supreme Court and not necessarily an advisory opinion. So I'd want to hear what Nyambura says in his light.
I'll ask you a question, Njeri. So when you're approaching the Supreme Court to get an advisory opinion, what exactly are you telling the Supreme Court to do? Are you telling the Supreme Court to decide on a matter? Or are you telling the Supreme Court to give, to tell you what their interpretation of a certain law is? What do you do when you're asking the Supreme Court for an advisory opinion?
It is to give their opinion on the matter that I have raised, the issue that is in question.
Let me ask, what is an opinion in your plain language interpretation?
Maoni.
Thank you. So the Supreme Court is giving its maoni.
I am sure this is bringing a lot of heat because I saw this question in one of your project work. But here is what I'll tell you. I saw that whole decision when someone asked me about advisory opinions, and how would I put it? The Constitution says that the Supreme Court can give advisory opinions. So if you actually go back to the Naitangwa Black Law Dictionary, if you look at its definition of an advisory opinion, let me just read it for you. Non-binding statement by a court of its interpretation of the law on a matter submitted for that purpose. So you've submitted that matter to the Supreme Court for an opinion. So what they need to do is give an opinion. But I made it very clear. Now, if the Supreme Court says that a random thing they can say is that all government bodies need not have more than 100 vehicles, probably from an interpretation. Let's say they were trying to interpret a certain clause or a certain law. If it remains an opinion, then it is not binding. However, let's say an NSSF or someone goes to court suing NSSF for having more than 100 vehicles. So if the Supreme Court makes a decision from that matter coming up and says that the NSSF is on the wrong for having more than 100 vehicles, then that decision of the court will be binding. But for opinion, it is not binding. It is merely an interpretation of the law, because basically, if you're asking the court to give an opinion, you're not telling them to rule on a matter. They're not ruling on anything. That is why you are asking them to advise you. Had it been a dispute or anything, you'd have gone to court ikiwa kama kesi. But now you're just telling them, ebu interpret for us this certain clause, ebu tell us what it means. So if they tell you, then you cannot now go and say, ulikataa kufanya vile Supreme Court ilisema, because even this decision is not on anyone. It doesn't have any consequences. It is just an opinion. That would be my response. However, you could have a different opinion, which is, tunasemanga kwa hii sheria, all opinions as long as they are backed by law are legit. But that would be my interpretation.
Thank you, Nyambura. Thank you for your response. Well noted.
You're welcome.
I'm just wondering on the same, this is Salim.
Yes, go ahead, Salim. Yeah, but I think Charity Munai. So, yes, something?
Yes. Can I go on?
Charity Munai, or there's an old one. Charity Munai, your face down. Charity Munai, your audio is on. You wanna say something? If not, kindly mute. Salim, are you still in?
Yes, I'm in. I just wanted to seek further clarification on the same. While I agree with Nyambura's explanation with regards to the non-binding nature of the advice or opinion, in terms of the party that took the matter before the Supreme Court, there is a twist to it. In terms of the parties that sought the court's opinion, that's okay. They can choose, it's an opinion. They can choose to abide by it or not. But how about the court, other courts? Is it even advisory opinion to other courts? That's a decision. Is rendered is a decision of a court. So for the parties, that's okay. But how about the courts that are lower than the Supreme Court? Is it also advisory opinion to them, or that's a decision of a court that is superior, that they need to abide by? Thank you.
Yes, Nyambura.
I'm actually trying to get a case law to that effect. I know it, lakini naiangalia. So give me a minute niipate. I just share it here. Then Salim and Njeri can look at it. I'll share it before we conclude. But basically, it's a supervisory opinion. So the Supreme Court didn't make that decision. That is my argument. So it could be a whole different argument for anybody else. But the Supreme Court did not make that decision. It gave an opinion. So it is not binding on anyone. It is an opinion. We are just being told this is how you interpret this law. I think what you can do if you approach other courts based on that decision is ask the court to consider that decision. But it is not binding on those courts because it was just an opinion. That's my argument of the whole thing. As I said, you could have a different opinion. But let me get that case I share with you guys.
Yeah. Salim, and
Okay.
I think
Daniel?
yeah, someone is speaking.
Yeah.
Can we just raise our hands before we speak? Maybe I think that will bring more order.
Okay.
So maybe you can just raise your hand so that we can all see you, so that you can go fast. Yes, Stephanie.
Okay. I'm also backing up what Nyambura is saying, but the decision binds only the parties, individual, or entities which have sought the opinion. However, it doesn't have any binding force on the other courts. And the case to be relied upon, I think I researched that when I was a second year law student, is the Division of Revenue Bill. That one, the Supreme Court tried to give out an advisory opinion. So when you read that opinion, it doesn't actually bind the courts, but only the parties, the houses of like the Senate, when they were seeking that division of revenue, like interpretation. Thank you.
Thank you. Which case did you state again, just so that other people can also jot it down?
I'm not really, unless I confirm the citation, but the division of the revenue bill, that's all.
Yeah, the one on division of revenue. Okay, thank you. I think
Yes.
the one on how money should be shared and everything. Salim, you want to add something?
Yeah, I'm getting lost by the last speaker when she says that the decision of a court binds the parties and the people who appeared before it, but not the court. I'm wondering then what is the role of the president? Because the president is all about a superior court making a decision, and that decision binds other courts. It doesn't mean that that decision has to be taken to those other courts. If a Supreme Court makes a decision like the Moratetu case, it binds all the other lower courts that are Section 204 of the Penal Code, to the extent that it provides for the mandatory death sentence for murder cases, is unconstitutional. It doesn't mean that that binds only Muratetu and other parties that were before Supreme Court. It binds all the courts in this country. It's a decision of the Supreme Court. I'm actually looking at another matter that was presented by Okiya Omtatah in the Supreme Court, and Supreme Court still said that their advisory opinion is binding. And I think I would be able to share that. I only wanted to ask that when we still argue with a clear pronouncement of the Supreme Court that their advisory opinion is binding, if I am asked that counsel direct us to the law, what will I say? Because court is not a court of opinion, it's a court of law. So if I have to advance an argument, then I must be able to provide the law. Note that in my opinion, I think they are not binding. So that we move forward, it's only fair that we provide the law, especially where the Supreme Court has pronounced itself clearly that their decisions are binding on other courts. We need another decision or the provision of the statute to help us get out of that, rather than an opinion. So if there was a decision that's being given, then that would be convincing than just saying that Supreme Court has said that. But in my opinion, I think that's defeatist, to say the least. Thank you.
Salim,
Thank
I've
you.
said I'm getting you the case law, so just hold on a bit.
Fair enough. Thank you.
I'm sending it before we end this thing. I had a similar conversation with one of your colleagues who is doing project work. So let me get it and then send it to you.
Okay, Salim, I think that settles the dust. Stephanie, yes, we can have Stephanie, then Peter, you'll come after Stephanie.
Yeah, I think, Daniel, there's a distinction between when an entity is seeking an advisory opinion or an individual person, and when a case is progressing from, let's say, from the magistrate court to the High Court to the Court of Appeal to the Supreme Court. You see that determination is meant reviewing the decisions of the other courts. So at that point, the decision of the Supreme Court will be binding. It will be actually setting a precedent. So now when we talk of an advisory opinion, the way Nyambura was saying, if an entity, a parastatal, seeks the opinion of the court on an issue, they don't just seek on anything, it's just a specific issue. It might not really be binding to any other entity, and their operations who never sought the opinion. They only sought as per their operations. Yeah, thank you.
Thank you, Stephanie. Yes, Peter?
Okay, just to contribute in the current discussion that is there, there's a colleague of mine who has sent me an excerpt that looks more of a case brief, and also has texted me some cases which talk of the binding nature of the advisory opinion from the Supreme Court. So I'll just read out some of the things that they have noted. The three cases that people should look at are the IEC case, the Interim Independent Electoral Commission case, as well as the Okio Mtata case mentioned by Salim versus Attorney General, and also the remata of gender representation in the National Assembly and the Senate. So all of them are in concurrence with the decision which the court rendered in the Interim Independent Electoral Commission case, which set the precedence on the interpretation of the question about advisory opinions. And the first one, the first case of the IEC, it says that regarding the binding nature of the Supreme Court, this Honorable Court stated that the standpoint of the Supreme Court differs significantly from that of the legal officers representing the Attorney General's chambers or any other governmental bodies that may seek an advisory opinion from the court. It further reasoned that because the Constitution mandates that its provisions be interpreted in alignment with the specified principles and policies outlined within it, an advisory opinion can be considered as decision rendered by the court as defined in Article 163(7), and therefore holds the binding authority over the parties presenting the matter to the court, as well as lower courts similar to any other decision. So the decision with regards to whether the same would equating the same decision in an opinion with the other decisions which the court makes, for example, the judgment, decrees, the rulings, and order, the court went further to state that on the enforceability or lack thereof, the court stated that although an advisory opinion may not be enforceable in the same manner as regular court decisions, such as rulings, judgment, decrees, or orders, it should still be regarded as an authoritative statement of the law. The opinion should guide the behavior of not only requesting entity, but also subsequent government or public actions. To hold otherwise will render Article 163(6) of the Constitution meaningless and lack significance. The binding nature of advisory opinion aligns with the constitutional values, particularly the principles of the rule of law. So those are specific excerpts that are coming from the decisions which the court rendered with regards to the question about advisory opinions. Yes, so I'd want guys to go and look at those decisions which offer further clarity with regards to that question on advisory opinion and its binding nature. Thank you.
Okay, guys, I think the dust has settled. Thank you so much, Peter. Thank you so much, Salim. I think this is something that you guys have on your project marks and is project work, and it's something that you're working on right now. And I want to believe that people have different opinions. Yes, Nyambura has her opinion. She has explained. She has underpinned the laws that she's depending on. Salim, you have your opinion. You have explained, and you've informed us of what you think about it. I think Stephanie also explained, and Peter also explained. Again, the way we said, yes, the law is there. The law is there. These things can always be challenged, but that doesn't mean that you can't have your own opinion, and that doesn't mean that you can't have your own argument. Salim, if you have the right arguments, then yes, the court would say yes. Peter, thank you so much for what you've shared and everything. I think it makes sense. I think we must also agree that what Nyambura shared also makes sense, because of course there is a difference between an advisory opinion and the normal judgments that people make in court. But again, as Peter explained, I think in the last case that he said that even though those two are different, those two are authoritative, because they're coming from the Supreme Court. You can't imagine a situation where someone went to the Supreme Court gave an advisory opinion, then today I'm going to the High Court. Then the High Court, tells me that, oh, actually what they said is wrong. The advisory opinion that they gave is wrong, and this is what we think is the answer to this question and all that. Of course, it wouldn't look respectable, of course, because this is a higher court and they ought to, at least to some extent, just respect it. So to that extent, then again, someone would argue that it is binding on them just because it's a higher court. But whether it is binding on them as a precedent, of course, that's a question for another day. I think maybe that's a question that will only be settled by the courts one of these future dates. Again, someone would argue that the question has been settled by the courts. Yes, so I think let's let it settle. Let's have our opinions. I think so long as we can back it up, then we are good to go. Sally, maybe just your last comment.
I actually wanted to let it rest until what you have just said now, and that it has a binding effect, but whether it has that binding effect as a precedent is what is yet to be settled. And I'm reading a decision of Justice Mumbi Ngugi in a matter that I will share, and he says it at paragraph 60, that as the highest court in the land, it cannot be disputed that the decisions of the Supreme Court in terms of have binding effect on all in the land. He's actually responding with the question of advice or opinion. In light of the hierarchy of courts and the doctrine of precedence that is extant in this jurisdiction. So while while giving a decision on the advice or opinion, the question is responding to, he's saying that it cannot be disputed that the decision, once the High Court, the Supreme Court gives a decision, then that's binding. Even to be more exact, is paragraph 59, it is the petitioner's case that the opinion is binding, and then they agree with it. That is a decision of the court and is binding in terms of precedent. So even as you say that whether it binds in terms of precedent is yet to be settled, I think Justice Mumbi Ngugi later on came and said that it's still binding on them as the courts, as a matter of precedent, and in terms of hierarchy of courts. But we can let it rest so that we move on. Thank you.
Yeah, I think even as we let it rest, hierarchy. I think hierarchy is really playing a very, very big function in that particular, when it comes to advisory opinions. Yeah, I don't think a judge would just decide to go against it. So binding, yes, binding. For me, I'd like to put binding with some quotes, but yes. Because again, if you go back to the Supreme Court, it will just give the same judgment. So really, why not just go with it? Anyway, the way you said, Salim, question for another day. Guys, I know we've had a heated debate, but I know we've learned 1, 2, or 3 things. I know now we have more arguments for and against, and everything is maybe clear, not very clear, but I think we continue to do our research, and yeah, that is what we have for now. So I'd like us to have the next person. Guys, thank you so much for this. We like it when we have these debates, by the way. We like it because it opens up our minds and it helps us to think differently, and it also helps us to know new things. We continue to learn each and every day. So let us consider what Nyambura will share. Let us consider it objectively. Let us also consider what Salim will share, consider it objectively, and also consider what Nganga will share. Yes?
Actually, Daniel, I've just shared a case.
Yeah.
If they have time, they can just go through it, and then probably we can have this discussion next time.
Yeah, true. Yeah. So let's do that. Yeah. Thank you. That's beautiful. Angelo, are you ready to go with me? I can start, then you'll be next. Angelo?
Yes, please start.
Okay, fine. I'll start, then I think you'll go after me. So anyone would like to try? Salim, you're very active. I believe that you can answer some of these questions. I don't know if you would like to give it a try, Salim.
Maybe at a later date. I'm participating in this while also following up on something else that may distract me.
Okay. It's just a few minutes, but all right. Anyone else? Anyone else would be willing to engage with us? Anyone else, guys? Peter, if you can see any hands that are up, or Angelo, just let me know. I don't want to miss.
There is no hand yet.
Okay. Any hands? Any takers? Guys, anyone? How we call it a night? Anyone who is willing to? Yes, Alice, thank you. How are you, Alice?
I'm good. Hi.
Kindly just
Hello?
introduce. Hello,
Can you
we
hear
can
me?
hear. Yep, loud and clear.
Okay.
All right.
My name is Alice Karianjeru, a student at Kenya School of Law, undertaking Advocates Training Program. I am in Class D, farm number 16. My registration number is 2023-0993. And I'm ready to proceed.
All right, Alice. Which sport do you enjoy, Alice?
I'm not really a sports person.
Okay, what do you enjoy?
Mostly, I do watching or road trips or hiking, all those stuff. But sports is not my thing, really.
Okay, what are you watching currently?
The Boys.
All right. Would you be okay answering? What if you weren't comfortable answering that question? Would you still answer it, or is there any part of any provision of the Constitution that you could have raised and brought to my attention?
Pardon?
What if I asked you that question and you weren't comfortable answering me? Would you still answer that question, or which legal provision under the Constitution would you use, or would you bring to my attention, and would you as a reason as to not to answer the question?
Okay, thank you. I would say Article 31 of the Constitution, I have a right to privacy. So I do not necessarily have to tell you what is going on in my life, including what I'm watching currently.
All right. What if the information that I inquired from you is public information and not private? It's not from a individual, but it's from it relates to a public entity, not it's not an individual kind of information. It's not personal, really.
Okay, if it's something that is already in the public domain, then I think I would only discuss to the extent that is already known out there. But if it's, let's say you're saying it relates to a public body, yeah, if I heard you correctly, I think, sorry?
It's an information that belongs to a corporate entity, not an individual person.
Yeah, still, a corporate entity is a person as defined under the Constitution. So it's a legal person, yeah? So I cannot talk about matters which are private to such corporation. And I will only discuss to the extent of what is already in the public domain.
All right. Have you gone through the Data Protection Act?
Not extensively, but yeah, personally I have.
your opinion, does it cover both information held by corporate entities and personal persons, or individuals, or does it only cover personal information?
I would say both. Okay, thank you for the question. I would say both because under the definition of a data, what are they called? A data controller, it can be an entity and it can be a personal, a private person. So I would say a data controller falls under the category of both private and public bodies.
Okay. Do you know anything about the case of National Bank of Kenya versus Anajua Housing?
Yes, I do.
What do you know about it?
Okay, the case talks about the requirements to practice or rather to prepare conveyancing documents. So it led to the addition of a section 34B of the Advocates Act, because previously we had the case of Wilson Ndolo, which held that you cannot, documents prepared by a person who does not hold current practicing certificate are not documents. And then the judges were of the opinion that that would mean fraud for the people who actually come to court claiming that they cannot pay the loan just because the charge was not prepared by a qualified person. So the Anajua Housing came to remedy that situation, and it led to the Section 34B of the Advocates Act, which introduced some of the documents which can be prepared and can hold a legal effect even if it's prepared by a person who is not qualified, as stated under Section 9 of the Advocates Act. That is, the person should usually have a current practicing certificate. So in such an instance, Article 34B talks of charges or other conveyancing documents prepared by a person who does not hold a current practicing certificate can be enforced as legal documents in a court of law. Yeah.
Okay. Alice, what would happen where this person you're talking about is not even an advocate?
Okay. Section 30, I'm not sure I remember correctly, but I think it's Section 41 or 40 of the Advocates Act, talks about an advocate employing an unqualified person, specifically in matters of let's say drafting in general. So you can, as an advocate, you should not engage the services of a person who is not an advocate. Yes, you can do a lawyer, that is like a person who is just has a background in law, like a degree, or maybe you can have such a clerk in the office. But again, you should go through these documents and make sure that they are endorsed by the person who actually drafted them, as provided for under Section 35 of the Advocates Act.
So what if they weren't endorsed by someone who is already an advocate? They were totally prepared and probably witnessed by someone who has a fake stamp, and this person is totally not an advocate. What would happen?
Okay, thank you. In that case, I wouldn't think they would be binding because, again, these are legal documents. They are documents that should be presented in court, and the law has already provided circumstances under which documents should be accepted. So if it's someone who is totally not an advocate and they have prepared this document, the same have not been endorsed by an advocate or a law firm, then I would think that those documents would not be binding.
All right. In that instance, what would be your remedy?
Okay, thank you. In such an instance, maybe a remedy for the person who is claiming or the defendant? Who is who?
Have a charge and you need to pay us back the money.
Okay. I do not have an answer to that right now, but given time, I will acquaint myself with it.
Okay, fine. Give me some of the parties to a conveyancing transaction. 5 parties at least.
5.
Yes, 5 parties to a conveyancing transaction.
Okay, I would there's a vendor, that is the person who is selling. We have the purchaser, that is the buyer. We have the charger. The charger is the person who is we have a charger and a chargee. So a chargee is the person who is securing the property as security for the financial provision that they are giving. So that a chargee can be a bank and the charger can be probably the purchaser. We have the mortgager and the mortgagee. So a mortgager is the person who benefits from the interest that is transferred by the mortgager on behalf of the, let's say, the security that they are getting. We can also have just those ones.
All right. Is there a difference between a mortgage and a charge? And if there's one, kindly let me know of the difference.
Okay, thank you. So a charge is basically a security to let's say a loan. So a security in the sense that a charge is an interest in land that secures the payment of loan, the payment of money or money's worth, or performance of an obligation. So generally, when we talk about a charge, we are talking about an interest in that land. But when we talk about a mortgage, we are talking about the transfer of this interest. So generally, in a charge, you do not transfer the interest from, let's say, the charger to the chargee. But you see, when we come to a mortgage, you are transferring the interest such that the mortgager probably just has the possessory interest, but now the ownership interest is vested in the mortgagee until that person completes payment. So in terms of a charge, the only time the chargee can have the possessory or the ownership interest in that property is when this person has actually defaulted and they have gone to court and all that. But you see, in a mortgage, you've already transferred the interest to the mortgagee. So the mortgagee is already the owner, but upon the payment of, let's say, the loan that you have, the mortgagee then transfers back the interest of ownership to you. That is what I think, but I stand guided.
All right. Last question. What is preemptive right or right of first refusal, and in what instance would it apply? Just one instance. Preemptive rights or right of first refusal.
Okay, thank you. I would say probably preemptive rights applies in compulsory acquisition, and whereby the owner of the land has the right to probably withhold consent from the government. But I'm not so sure about that though.
All right. Alice, Angela?
Maybe you can give your feedback so that we can, I will start with the next candidate.
All right, that's
yes.
Ali. I think Angela has realized that you are answering all these questions correctly, and he's worried. it will only be a waste of time to still have you on the stand. But I think, Alice, you've done well. I think you've answered most of the questions correctly. About mortgage and charge, yeah, I'm impressed. That's the answer right there. And I like the way you've spent your time to elucidate, to explain cleanly, to emphasize on what is what and why what you're saying is right, and all the aspects of it. Then the last question, I think you've struggled with it a little, but at least you tried to give an answer. Again, one thing that I'd like to emphasize on is this notion of I stand guided, and this notion of I believe, I think, this and that. So where you want to give an answer and you know the answer, try as much as possible not to say you think. Because if you think, you're telling me that I'm not sure, Daniel, but this is what I think. This is my opinion. I'm not sure, Daniel, but this is what I think the law is. I'm not sure. But if you tell me this is the law, this is the answer. Okay, so if I ask for them, what is preemptive right? Preemptive right is this, and this. Okay, but when you keep saying I stand guarded, this is my opinion. Sometimes it could even water down that which is right. Just because you said I think before. Because I like, for example, I think the time my lecturer asked me, you think, Ama, because I kept using the word I think, my opinion, I think, I believe. Yeah. So where you know the answer, just go straight, answer the question. Try as much. I know sometimes we have that temptation of, you feel like you want to say, I think. Lawyers like saying during debates that it is my opinion. My opinion is that. My opinion that. We want to know what the law is saying. We want to know, what the rules are. Then I think preemptive right or right of first refusal. So, for example, think about a lease. So I have a lease with the government for, let's say, 99 years, and my term is just about to end. So the government, it is written under the Act, the Land Act to be exact, that the government has to give me an opportunity to first refuse to extend this lease before this lease goes to anyone else. I have the right of first refusal. It must be that the government came to me first. Daniel, your term in this lease is about to end. Would you like to renew it before you give it to someone else? And it's only when I do not reply or I tell them that no, I don't want to renew it, that the government would sell or give the lease to someone else. It's the same way when we're talking about issuing of shares in a company, public company, for example. It is improper. It is improper that if shares are just issued without first giving the shareholders who are present the preemptive right, the right of first refusal, for them to say that, okay, fine, we know that you're selling these shares, but we're not able to buy them probably because we don't have the money. So basically, preemptive right is the right to refuse the first person. So when you're talking about a lease, is you are the person who's leasing this property, your term is about to come to an end. Of course, when the time comes to an end and it's not extended, then the government would give the lease to someone else. The government will have to first come to you and ask if you want to renew, because you have the right of first refusal. That's the preemptive right that we're talking about. I asked about NBK versus Anajua housing. That was proper. You explained everything well. I like the way you went into Wilson Dolo IR. And I mean, that was nice. At least now, we were able to move from the old regime to the new regime, and the reason as to why we actually have that particular decision. And I think, that was very well explained. Then I asked you a question at last. And the reason why I asked you that is because I feel like sometimes some people use this case of, Anajua housing versus, National Bank of Kenya blanketly, without looking at some of the very salient factors, or some of the very, very salient parts of it. If you look at paragraph 68 of that decision, the court says that no instrument or document of conveyance becomes invalid under section 34A that I think you've talked about of Advocates Act, only by dint of its having been prepared by an advocate who at the time was not holding a current practice certificate. Yeah. But however, if you move on, documents prepared by other categories of unqualified persons, such as a non-advocate or advocates whose names have been struck off the roll of advocates, shall be void for all purpose. So you have to take note of that. So Anajua housing only deal with cases where we're talking about the issue in question is, practicing certificate, but where this is an advocate or they've been struck off from the role of advocates, you cannot say that those particular documents are binding. So that's a difference that we have to have at the top of our minds. Then which other question did I ask you? Which other question did I ask you? Yeah, so where you've made losses because there was misrepresentation. Remember, you had a contract with this advocate, so it's a contract. Under contract, there are so many remedies that you can still use and ensure that you get back your money. So under the rule of contract, yes, there are remedies that you can use, rescission and damages and all that, to get back your money from this person who is an imposter and not even an advocate. And if you take them to court, then you'll be able to get back the money. Alice, do you have any other question?
No, thank you. Thank you so much for that.
All right. So you have to ensure that you know that difference, and that where that is not the case, you cannot say that we are going to use this. You go to court. There's a contract, and you'll get your remedies out of the contract. But Alice, one thing I want to say that I like your confidence. I like how you answered the questions. I like the fact that for the ones that you know very, very well, you spent your time and explained them. I'm convinced, Alice, that you know what you're talking about, that you're on the right track, that you know your stuff, and I could have given you, if I was, the panel, I could have given you very, very good marks. So I think that's one thing that people can also learn from you. Where you get something that guys, eat it without a spoon. Like, explain as much as you can. Explain, and of course, not so much, but ensure that you explain it plainly and simply. Ensure that you tell the panelists that this one I know. Angelo, go ahead. Thank you so much, Alice.
All right. Thank you, Daniel. That is it. If you really know something, please give your best, because that exams is only for 10 minutes, and you also read the mood, so such that you don't over explain something. So maybe we can have the next person. We are left with about 42 minutes, such that we can close the session. Who is next? Who is the lucky winner of today? It will be quicker, and I promise I will only ask simple questions. Daniel, who was supposed to follow Miss Njero? I thought there were 2 hands up before.
Yeah, we had 2 hands, but I can't see any other hand. Anyone else who would like to maybe? No, now we're in the dying minutes. We're just about to finish, so really, it's nothing serious. Please, if you are able to take a few questions, then I think that would really help us to move forward. So anyone who'd like to take a few questions from Angelo so that we can move. Again, now we're doing 1 person per session, so really it won't be a tall order. Anyone? Sorry. Yes, you have someone. Bet Chelagat.
Yeah, Chelagat. Okay, so I'm privileged. I will be examining government. So, Ms. Chelagat, please introduce yourself.
My name is Chelangat Castin Bet from class B, Farm 14. My registration number is 2023-0454. I'm privileged to be here today.
Okay, thank you so much. If your questions will be easy, I have not been bribed whatsoever. So, please give me instances where a case may be terminated before full hearing in civil litigation.
Where the first instance where a case can be terminated full hearing is when maybe the defendant has filed a memorandum of appearance, but has failed to file a defense. Then a summary judgment will be given, and then the other instance whereby the defendant has filed a memorandum, has not filed the memorandum of appearance, or they have not filed their defense, so a default judgment will be entered against them.
All right. Is that all on your
Yes.
part?
Yes.
Oh, okay, thank you. Can you please tell me which documents that accompany a plane? Sorry, I was muted.
Under order 5, a plaintiff is accompanied by a verifying affidavit and a list of witnesses, list of documents, and witness statement. That's all.
Okay. Are you sure it is order 5?
Order 4. Sorry.
All right. What is your understanding, or what do you know, or what is a preliminary objection?
A preliminary objection is whereby someone is raising a point of law in an application. So a preliminary objection can dispense with the matter at that instance. Thank you.
All right. Can you please tell me ways of responding to an application?
Under Order 51 of the Civil Procedure Rules, there are three ways of responding to an application. The first one is grounds of opposition, preliminary objection. The other one is through a replying affidavit.
Okay. Thank you so much. Can you please pick for me 3 pleadings that you know and the ways to respond to those pleadings that you have chosen? Any 3 pleadings that you know and how to respond to those pleadings.
So the 3 pleadings that I know is the plaint, which is responded to by way of a defense, and then a memorandum of claim, which is responded to by way of a response to memorandum of claim, and then there is a petition, which is responded to by way of a replying affidavit. Thank you.
Okay. Finally, how do you attack a pleading?
You can attack a pleading by filing a defense, a counterclaim, or set off.
Very well, very well. Then finally, because we are in the dying minutes.
Yes.
Okay. Please tell me or differentiate for me recruitment and selection.
We have not reached that topic yet, but I can try.
Okay.
Recruitment is whereby.
No problem. Let me substitute it. Do you know? Have you read or have you come across a case of Felix Kiprono versus Attorney General?
Yes.
Yes. What was the principle or a dictum in that case?
The case was about judicial review. And the question was whether the leave stage has been removed in the application for judicial review, whether a leave stage has been removed under the new because because there are different ways of applying judicial review that is under the Constitution in Article 23, and the other way is by Order 53 of the Civil Procedure Rules. Thank you.
Okay, that is all. Daniel, do I give my feedback?
Yes, of course.
Okay. Okay, everything. I believe you did well. I can give you a 17 or 18 for all my questions. Maybe the first question you tried, but when you are trying to give me the instances, for example, you start a circumstance and then you tell me it is a summary or default judgment. A follow-up will come and tell and state that you can differentiate between a summary judgment and default judgment. Okay, that might be a question for another oral session. But the instances whereby a case might be terminated before full hearing or full trial is ADR. It is something that is taking over, by the way. So ADR is one thing we can decide, go and negotiate outside there. Then if we are in agreement, then we come to court such that if there is a consent or if the arbitrator or the mediator, they file their report that the consent has been entered, then people come to the court and then the consent is adopted as an order of the court, which leads me to the second one. It is consent of the parties. They can consent for the matter to be withdrawn or something like that, or for that particular consent order to be adopted. Then there is that summary procedure. Okay, then we have default judgment and something called discontinuance by the plaintiff or the person that filed it. So the rest of the questions, you have answered them well. So I'm not going to comment, but just to say, for example, when someone asks you about preliminary objection, your answer will not be complete until you tell that person about the case of Kisa biscuits. Okay? That is the locus classicus case. Everywhere you go. So when you are explaining a preliminary objection or when you study your pupillage and you are told to draft, let's say, submissions on a PO, then it has to be, must be ensured that it meets the requirement that have been provided for in that Kisa biscuits case. Okay. Then finally, on the Felix Kiprono versus Attorney General, so it is on the aspect of judicial review, the leave stage, the substantive stage, whether it is really necessary, or do we just go ahead and you file your petition? But you have to remember, if you read, I don't know if it is paragraph 94, paragraph 95, or 96 of that case, you realize what Justice Dr. Sergon, what he said, it was obiter, it was not a ratio of that case. Okay, it was actually his view, because the rules that were supposed to be made by the Chief Justice, they were not. The regulations that were supposed to be drafted by Parliament, they were not drafted. So Lord Justice Dr. Sergon did not per se say that it is the position that there shouldn't be a leave stage. No, it was his position because he doesn't see the need why we should go through this procedure of leave stage, and then you are given leave, then you file your substantive application. So according to him, is that nowadays we do call them, they are like constitutional, they are not like, how do you call them? They are not read like those ones of before that were provided traditionally, but they are constitutionally provided for now under Article 23. So according to him, there is no need for us to go this aspect of substantive or leave stage, that we should just file directly. So that is it on my part for now, Daniel. She did really well. I'm impressed. Thank you.
Nice. Thank you so much for that reaction. And of course, thank you so much also for Chelangat. Thank you so much for, the participation. I hope you don't have any question, Chelangat.
I have a question, but it's on probate.
Oh, not on the questions that Angela just asked you, right?
Yes.
No problem.
So in a will, is it a must that in making a will, in writing a will, is it a must that one of the parties be present during the signing of the will, or both?
That is an interesting question because it is an interesting area in the sense that, you know, the act is saying one thing. I don't know, is it section 11 of the Law of Succession Act? I don't have my act here, but on the aspect of is it attestation or sign when you are now signing the will, whether both witnesses have to be there when you are signing the will. Is that the question you are asking, Bet?
Yes.
Yeah. So some people have always said that both witnesses must be present, but actually that is not the position. What is the position is that they must acknowledge that that particular signature is for the testator. Okay, because there's no way, like if both witnesses, if we say that both witnesses must not be present, that this means that every time that a witness comes, then the testator will have to sign again? No. So a testator can sign, but when the other witness come later, the testator can acknowledge that this is my signature, and then the witness, if they are not present. But it is good if they are present at the same time, fair and good, but there is no requirement that all of them must be present at the same time. I don't know if that is the correct position. Maybe Daniel, you can interject.
Yeah, I think attestation is dealt with clearly by the section that you've talked about. So maybe, I don't know, do you want to read the section for us, Bet, or can I look for it? Then we read through it so that we can see what this section is saying.
I
Because what
can read.
I believe the section gives us different.
Section 11C, the law of succession.
Just read section 11, if you can.
Section 11, no will shall be valid unless A, the testator has signed or affixed his mark to the will, or it has been signed by some other person in the presence and by the direction of the testator. B, the signature and mark of the testator or the signature of the person signing for him is so placed that it shall appear that it was intended thereby to give effect to the writing as a will. C, the will is attested by two or more competent witnesses, each of whom must have seen the testator sign or affix his mark to the will, and have seen some other person sign the will in the presence and by the direction of the testator, or have received from the testator a personal acknowledgement of his signature or mark, or of the signature of that person, and each of the witnesses must sign the will in the presence of the testator, but it shall not be necessary that more than one witness be present at the time, and no particular form of attestation shall be necessary.
So, yeah, I think my opinion that is very clear. You're given different situations. One is that the will is attested to by two or more competent witnesses. That's the first one, and I think that is very clear. And I think when it says the word competent, we know what it means, competent. And of course, we also have to take into consideration the fact that there must also be independent witnesses. Then each of whom must have seen the testator sign or affixed his mark to the will. Then they've used a disjunctive or they're not saying and. So there's another option, or have seen some other person sign the will in the presence and by the direction of the testator, or have received from the testator a personal acknowledgement of his signature or mark, or of the signature of that person, of that other person, and each of the witnesses must sign the will in the presence of the testator, but it shall not be necessary that more than one witness be present at the same time, and no particular. So yeah, it's not a must. I think it's very clear there. So sometimes it could be an acknowledgement. It doesn't have to be that you are there when I am signing. It doesn't have to be that the both of you are there when I'm signing. Sometimes it could be an acknowledgement that I actually signed. Is that okay, Chelangat?
Yes, thank you.
That's how you use the word the disjunctive or. So that gives you those particular options. You just have to ensure that at least you meet those options. Yes, Kibi.
Good evening. I have a question regarding the questions that Angelo asked the immediate was it Chelangat? Yeah, on ways of attacking a pleading. Can we add a preliminary objection so that if, for example, a plaint has been filed and then I have filed my defense, and then I feel that there is issues of jurisdiction, maybe this matter has the issues of res judicata, then I can file a PO to attack that that pleading so that it can be dismissed with that stage. Then I have another question. When it comes to, it doesn't relate to what we have discussed today, but it's on commercial. I think from the way we were taught in campus, the issue of insolvency, the way our lecturer brought it out is that insolvency relates to companies, and then when it comes to bankruptcy, we're talking about natural persons. But when you look at the wording of Insolvency Act in the long title, it relates to, you know, the insolvency of a natural person and the liquidation of a company. So maybe you can shed light to that as to the definition of the insolvency and what it relates to. And the last question is on probate. This is to the effect that if we have children of the deceased who feel like who feel that in this succession issue they've been left out and they want to participate, can they place a caveat so that they can be notified as to what is going on in the administration of the estate of the deceased? Thank you.
What was the last question, please?
The last question relates to probate, or when it comes to children of the deceased who feel like this administration of the estate of the deceased, the whole process, they've been left out and they don't know their role. Can they place a caveat so that before confirmation of grant, they can be notified as to whatever is going on into the estate, or what can they do so that they make sure that they participate in the succession of the estate of the deceased?
Okay, so when you talk about children, you mean those who are below 18, yeah?
Yeah, both. Both.
Okay, so of course caveats can always be put, and of course the intention is so that you know what is happening, and of course it would apply in the situation that you're talking about. So I don't think there's any restriction. However, if you're talking about a child who is children who are below 18, then they can only do it through a guardian. Yeah, I don't think a child who is below 18 would go to court and file the right proceeding, the right pleadings, and ask to be informed, because again, we don't even know whether they can make the right decisions. I mean, they don't have that capacity. So yes, they can do it through a guardian or a trustee, for lack of a better word. Then of course, if they're above 18, then they have the right to, because they have the legal right to know. If they have questions that they need answered, I want to believe that if there are things that they need to be told about and the thing that they're not being told about because they have interest, their children, they have interest, I want to believe that they have the right to put that caveat. Now, I'll try and answer the other question that you asked, then maybe I'll leave the rest to Angelo, if you can, or yes, I think Nyambura is also still present, and Hezbon. So yes, the question that you asked on, or Angelo, you want to go first?
Yes.
Want to answer?
Yes, I will go first. I forgot to answer the aspect of attacking a pleading. She actually mentioned two counterclaim set-off is one of them. But the other way is that you can deny or traverse. Okay. Then you can, there's something called defense of a tender. Okay, those are some of them. There are several. I believe S1 can comment on the others. Then on the final question, I will not comment on the aspect of insolvency, because my understanding has always been that insolvency refers to, okay, there are two ways. There is that one of what is known as bankruptcy, which refers to natural persons, and then insolvency to artificial persons. So, but they are all governed by the Insolvency Act, which actually repealed the Bankruptcy Act. So I believe someone will substantively comment on that one. However, on the probate, so it depends with what type of succession proceedings that we are undertaking. Is there a will or is it intestate? Okay. If these children have been left out and there is a will that was in place, okay, and maybe for one reason or the other, the parent decided to leave them out, then they can make an application under Section 26 of the Law of Succession Act, something called reasonable provision. Okay, so that one, it has been explained clearly by the Court of Appeal sitting in Mombasa, by it is case of Popat versus Popat and another. It was decided recently, I don't know, was it in 2021? Okay, and there is another High Court case. I will try to find it next Saturday, such that when you are in oral setting, those two cases, they are always, if you use them to explain Section 26 in an oral exam, you can really score. But now, let's say if still, okay, that is one way, that is if they have been left out in a will and they would like to be provided for something, okay? Reasonable provision, it doesn't mean that it will be given equal to the others who have been provided for under the will, but the judge is going to examine, will juxtapose the same, will consider all the circumstances provided under Section 28 of the Law of Succession Act, and then we'll see what will be reasonable in the circumstances. But again, let's say before the will is confirmed, you know the procedure. Last time I directed you to look at that case of Lady Justice retired, Mary Angao, on the process of, on the probate procedure or the procedural aspect of it of the law of succession. Okay, there's something called an objection. Okay, then after that there's something called protest. Okay, thereafter there's something called revocation. I don't know if it is Section 76 or is it 77? I don't know, but it is either of the two. Okay, these are instances whereby, for example, if someone is misusing the estate or it is not administering it in accordance with the grant that has been provided, then they have to approach the court. So what happened is depend at what stage. Okay, of course the first one will be the aspect of objection. Okay, if you are objecting to that grant be given in the interim before it is confirmed, then if it is later confirmed, then you have been left out for some reason or there are some other circumstances, you can protest against the confirmation of that particular grant. Okay, but later on, as people go on, someone is misusing the SSU, what is happening, you can still apply. You can file your summons and then you revoke that particular appointment or that particular grant. So that is my response, Daniel.
All right, Kibi. I don't know if your question was on the process or caveat, but I want to believe that whatever I said and whatever Angela said fully answers your question on your probate question. Then again, I think he has also addressed your first question. Then there's a question that you've asked about insolvency and bankruptcy. Hezbon, would you like to answer, or would you like to take that question if you're there? If
yes,
not,
I'm actually. Hello. You
go
can
ahead
hear
then.
me, right?
Go ahead then.
Yes. I want to admit I did not really get her question right, but I have had the conversation. I think the clear distinction between insolvency and bankruptcy, and what is actually important to know, and the distinction between the two. Of course, first of all, is that currently the two are being regulated by the same act, which is the Insolvency Act. Then the key difference between the two is that insolvency relates to artificial persons, for example, companies and whatnot. Then for the bankruptcy, it relates to individuals. So I really did not get her question, but if the question was what's the key difference between the two, then the difference is that bankruptcy relates to individuals and then insolvency relates to natural persons. Sorry, insolvency relates to artificial.
All right. Kibi, would you like to maybe repeat your question?
Okay. My question, I am actually seeking clarification on the same because my understanding is the same as what I think Angelo said and what you said. But there's a discussion I had with someone, and then they were telling me that because we have the Insolvency Act, and it is now the Insolvency Act, it is bringing them together. But now we're under insolvency. Insolvency relates to both. And then under it, now we have bankruptcy for natural persons and liquidation for artificial persons, that is companies. So that is why I was seeking a clarification, because from my understanding is that insolvency and bankruptcy were the main branches. But from that discussion, I learned that insolvency is like the main, and then under that we have now bankruptcy and liquidation. So maybe you can shed light on that.
Okay. Odur, with your permission, allow me to respond to her question. And before I respond to that, just like, for example, we know about bails and bonds, and most of the time you asked, what's the difference between bail and bond? And most of the time you see people say there's a key difference between bail and bond. So some others say for bail, it is when they're using cash. Then for a bond is where you're using, for example, other titles. But the importance to know is that bond is like the umbrella, then bail is under that umbrella. So the same case applies to insolvency and bankruptcy. So you are right to say that insolvency actually relates to both, because if you look at a progressive reading of what insolvency means from the Act, it's actually that situation whereby a debtor cannot pay what they owe. And in this case, a debtor can actually exist as a natural person or a company. So now it goes now further to narrow them down, so that it says, so if the insolvency is now is now being referred to individuals, then the procedure shall be bankruptcy procedure, so that now bankruptcy relates to natural persons. But then if it's in relation to the companies, organization and whatnot, then it shall be insolvency itself, so that now the insolvency relates to the companies or other artificial person, and then for bankruptcy relates to natural persons. So just know, like insolvency, as you say, it's right. It's like the umbrella. That is where they are all found in the Insolvency Act. But then when you now narrow down the situation where an individual cannot pay his or her debts as they become due is bankruptcy and shall be subjected to bankruptcy procedure. But the other one, if it's a company, it's insolvency procedures.
Kibi, do you still have questions?
No, actually, thank you. I have understood what you've said. Thank you.
Daniel, maybe just 1 second. You see,
No problem at all.
liquidation is just like an alternative. Okay. For example, we have administration. Okay, what is the alternative of liquidation? Because we have those no asset procedures. I don't know if you have studied yet the insolvency. Have you reached that yet, Kibi? Because I believe you will have a good understanding thereafter.
No, actually, we are yet to, but it is something I interacted with because my friends were doing a project work on the same.
Oh yeah, it is really interesting. But just know, insolvency is to companies or artificial persons, but for natural persons, it is what it is, bankruptcy. So it will get interesting as you go ahead, because you have to read administration. What is it? Okay. So that is what I can say for now. Thank you.
All right, guys. Otieno, Julie.
Oh, hi. Thank you
Hi.
so much. Thank you so much for this session. I wanted to remind you people, there's someone in your panel who was to give us an opening statement, a sample opening statement on the Shakahola. And didn't do it. You're supposed to do it during this session. I'm hoping he'll be able to do it the next session. I think Hesbon, I'm not sure.
All right, Hesbon, kindly confirm. I'm thinking it was Angelo, but Hesbon, please confirm.
Okay, thank you, Duar. And is it Otieno? Actually, I was supposed to take in someone for 5 minutes before you close the session, and the question that was asked on opening statement was actually asked by Angelo. It seems we actually a session was taken through by myself and Angelo, so that is why maybe you you thought it was me, but it's okay. So I don't know, Otieno, if you are comfortable, I take you through 5 minutes, and the 5 minutes shall include maybe an opening statement, a question on opening statement before we conclude.
Hesbon, I think Otieno is looking for answers. She's not saying she's ready. She's saying one of us was supposed to explain. So I think maybe Angelo, you can. I don't know if you can do it in the next session, because I think time is also well spent. And
Yes,
I think
yes.
Hesbon.
I believe it will be the first thing that we will do. I will give an opening statement on that Shakahola matter.
Okay.
So I believe the case was on that. Yes, it will be the first thing we will do on Saturday next week.
Nice, guys. So on Saturday we have something from Angelo on the Shakahola matter. So join early. Okay, Hesbon is looking for someone to, talk with for like 5 minutes. I think it's gonna be very, very short. So don't worry. I think maybe those are just like 2 very quick questions. Hesbon, again, I don't know if we have someone.
Yes, and I believe this is the time that we look for our lucky winner of the day, the final hour.
Yes.
So as Hesbon, maybe you can scroll through and maybe pick someone up.
Actually, the lucky winner of these becomes Gisheru, Mary Gisheru. Hi, Mary Gisheru.
Hi, Hesbon.
Well, thank you so much for. I hope so you have the intention to volunteer. Just a very brief session with you.
Yes. I'm okay.
Okay, thank you. Now, kindly introduce yourself, assuming we are taking the orals in the morning.
Good morning, my panelists. My name is Mary Gisheru, a member of Class D, Farm 6, and my student registration number is 2023-0873. Thank you for having me.
Okay, thank you, Mary. Now, I have some few questions for you, and the first one is, usually in during the administration of estate, the succession process and all, there is usually a stage where you will require a letter from the chief. Let's say the chief's letter in the area where that person was residing. So, as an advocate representing the deceased person, or rather, the deceased person's family and the estate, what do you think is the reason for you requiring chief's letter?
As an advocate representing the deceased, I would require the chief's letter so that I know and I be certain that this person hailed from that area, and also it would help me in deciding in case a case arose, a succession matter arose, maybe pursuant to maybe distribution of the estate, I would know where I would file my matter. Yeah, like which court, like
Okay,
which
thank you.
area.
Okay,
Yes.
okay, thank you. Another question is, you understand that there are actually various transactions you do, especially in conveyancing, right?
Yes.
Okay, now these different types of transactions are actually categorized differently depending on their features, characteristics, just their extent. So there is one we usually call a controlled transaction. So what is controlled transaction in your understanding?
Thank you for the question. Controlled transactions, these are transactions that require consent for them to proceed to their eventuality. And the one such transaction is a transaction involving sale of agricultural land, where you require a consent from the an LCB consent, yeah, land control board. So like without that consent, you cannot sell an agricultural land.
Okay, thank you. I also have another question, could be the second last question for you tonight. So you understand, like, once a person has been arrested by the police officer, there is a procedure that takes place. Then that procedure is supposed to be regularized by taking record of every activity done, so that if after a person moves from the police officer, the prosecution comes on, the prosecution is also supposed to undertake some activity which there is a clear procedure which the prosecution will actually undertake. And also during the same, they actually have to record them. So what they record, all those activities are what we call sub-files. So these sub-files are called prosecution files. So there are actually various files which I know you have maybe interacted with in the course of your studies. So it starts from sub-file A to sub-file G. So would you guys just mention to me just two prosecution sub-files and their content? Just two.
Thank you for the question. Just two sub-files. I will start with sub-file A. Sub-file A involves an a report. I'm not remembering that first word, but it encompasses the details of the police officer, the date where this person was brought, the name of the police officer who recorded the details, and also the second sub-file is the documentary report. Yes, and this one contains the photographs, the sketches that the prosecution came up with, and the other sub-file to cater for the one that the first sub-file where I'm not remembering the name is sub-file C, which involves the expert report, and this one entails the reports. Maybe it's the post-mortem that was conducted in case of a murder case. Yes.
Okay, okay. Thank you so much. So the final question to you, which I kindly request that you use maybe 20 seconds to respond, is you have done you have done 9 projects with your colleagues, right?
Yes.
Did you do commercial litigation? Commercial projects, commercial transaction projects?
Yes.
What was it all about? Just in 20 seconds, what was it all about?
If I may cut you short, sorry, I have remembered the sub-file A is an initial report. And now to go back to this question, commercial transactions, our lecturer was Mr. Mbogo, and our project was quite different from the other classes. But question 1 entailed matters to do with company, yes. And then it involved that topic of company law. And then the second question was about derivative claims. And then there was a question about partnership, then where we have sleeping partners and nominal partners and general partners. Yeah.
Okay. Okay, thank you so much. That is all, and all the best
Thank you so
to you,
much.
Bwana Odur.
Happy New Year.
Okay.
I think you can give your comments, husband, real
Okay,
quick.
I have very brief comments because of the time, and also because that my candidate has really done excellently. So honestly, I find no question where she was in Tata, though I realize maybe for prosecution file, she'll have to go recite them from subfile A to subfile J and also get to know the content. So guys, I advise you that you go through the subfile A to subfile J, and if you just understand the procedure of when police arrest you, what happens towards the end, you'll know how those subfiles are actually determined. Then the question, I honestly don't find any question which she has not answered. She has answered so well. The only trick which I would have actually convinced me to deny her 1 mark and give her 19 out of 20 would be when I asked her to answer in 20 seconds, she took 31 seconds. So, you're also there, they're judging you. Will you be able to use the time the judges allocate you? You understand? Like, you'll hear during the election petition, council, we are giving you 5 minutes. Are you able to keep that time? So be very careful when you're told about use 5 seconds. For you, not wasted, but you used 11 seconds extra because you started by introducing who your lecturer was, but at least I understand you participated in the project work. So guys, that was very well done from Mary Gisheru, and also seeing that I ambushed her. Thank you so much, and back to you, Daniel.
Wow, nice. Mary, I think you've participated twice, man. That's really nice. You started for us and now you've closed for us. That is really great, guys. Thank you guys for joining us today. Thank you guys so much for, I love this class, man. Honestly, I love this class. You guys are reading. The answers that we're getting from you guys are good. I'm even learning from you guys. You guys are really doing well. I love this class. I know that you guys will do so well. Just keep going. Keep pushing the way you are pushing. Just keep reading. Keep digging in. Just keep trying. Keep doing your best. Guys, people have done this. You guys will do it. You guys are going to pass. That's one thing that I believe. And I'm not saying it as a joke. We've been having questions here. You guys have been answering those questions and you've been answering them correctly. And I believe that you guys are on the right trajectory. Wenda Victor, could we deal with this question in the next session, if you don't mind? Because I think we are already past time. Victor? Victor, if you don't mind. I think your hand was up. Okay. Fine. So guys, just keep studying, keep getting ready. You guys are doing well, and I believe that you guys are going to pass your exams. Again, let's have more discussions as to whether you guys would like us to have a session within the week. Just reach out to me, reach out to Angelo, reach out to Hesbon. Just let us know. We'll discuss on it and we'll see what we can do about it. Now we're going to have Nyambura finishing for us with some quick advice and a word of prayer.
Thank you, Daniel. I have nothing much to say. You've said it all. And yeah, I agree. It's a good class. Keep asking those questions. If you feel someone has said something and you have something else to say, just say it. I am not a person who has a very fat ego, and I'm sure my colleagues are the same. So they'll listen, they'll look at the law, Of course, we may not agree on everything, just like you've already witnessed in probate. As different lecturers have different opinions. We may not agree on everything, but at least we will have supporting, we will support our answers or what we believe in. Otherwise, I wish you guys all the very best. Keep reading, keep reading, keep reading. Sometimes you can read even those two small details. Remember when I went for my orals, I'd read, and then I naulizwa contents of a sale agreement. So if you thought I had thought that was simple and passed, it would have been tough for me. So you can be asked the simplest question, or you can be asked a tough question. Just read. There is no formula to passing the orals. As Daniel kept telling us last year, you just have to read, practice. Because once you keep practicing, hiyo uoga inaishaisha, you get better. So even when you're appearing before a panel, you'll be ready to go. And you can never be 100% prepared. Even that morning, you will not be prepared. But as long as you've been practicing, at least you'll be at a good position than a person who hasn't been doing anything. So that's it from me. I'll close with a word of prayer, then we meet on Saturday. Let's pray. Dear Lord, we come before you this evening. We thank you for such a wonderful session. We pray for all the people who attended, oh dear Lord, that you remember them when they are doing their orals, oh God. Give them courage, give them the strength they need as they study for their exams, even as they are doing their project work. Pray for knowledge. We pray that you will guide them all through, oh Lord. Others have done it. There is no reason that they should think they can't do it. Give them the strength and strengthen their faith, oh Lord, so that they are able to conquer this fight, dear Lord. We thank you. And as we go to sleep, we pray for your mercies. We pray for your love upon our lives. And it is your name that we pray. Amen, amen, amen.
Amen. I'll see you on Saturday.
Amen. Thank you, guys.